I want to talk to you about the advantages and disadvantages of the current workers' compensation system and their empowering laws in Canada compared to workers being allowed to sue our employers in court. A workers' compensation system is one that is managed by government. Within all workers' compensation laws, the following has been identified by Canada's courts. 1. That individuals injured or made ill by our employers' workplaces are legally prevented from suing our employers for workplace injuries and illnesses. In return, we are provided a right to workers' compensation. 2. That the funding of the workers' compensation system is done by employers who are required to pay premiums to fund the workers' compensation system. In return, these employers are provided immunity from being sued by their workers when we are injured or made ill by our employers' workplaces. This the courts have called the historic trade-off. The advantages of the workers' compensation system, as identified by the courts, are most commonly known as speedy determination of benefits, or a right to workers' compensation. A worker is provided benefits right away, compared to if the worker were forced to sue the employer through the legal system. In suing an employer through the legal system can take many years for a legal matter to reach trial and final decision. Then there are the inevitable appeals, which can add even more years to this delay. The worker receives nothing while they're waiting in many cases. This means workers are in theory this means that if in the current system of workers' compensation, in the theory, is that workers are not a burden to their family, friends, and most importantly, taxpayers. Also, with having a speedy determination can arguably include immediate entitlement to health care treatment for the workers when they're injured. In some cases, preventing permanent injury. I say arguably because now the WSIB can deny health care even though you have a right to workers' compensation. Another advantage is protection for the workers from employer bankruptcy. If workers were forced to sue the employer and their employer went bankrupt, the worker would be left with nothing, leaving them to become a burden to their family, friends, and most importantly, taxpayers. Having a collective compensation system means that the workers are protected when the employers go bankrupt. However, now I'll look at the disadvantage of the current workers' compensation system, referencing the current laws in Ontario specifically. Other provinces are similar in many ways. The most notable concern is forced return to work. This is where the board says, well, I think you can work, so therefore I'm going to suspend your benefits. And this decision oftentimes is not based on any medical evidence. It is usually based on personal opinions of the decision makers, who oftentimes are not medical people. But in some examples, the WSIB has been using nurses to say that you're fine. But how can they say you're fine when they've never examined you? They're literally ignoring your doctors who are saying that you are not fine and cannot return to work. This raises huge medical ethics and legal questions, including criminal wrongdoing. At any rate, these are the points that I've come up with in raising concern or the negative or the con side of the current workers' compensation system in its current structure. I am not talking about the system that was created by Meredith in 1915. What I'm talking about is the system that we've de-evolved to. One of the disadvantages is the amount the worker is paid today. The loss of income paid to a worker is not even what they make prior to their injuries at their job. For example, here in Ontario, a worker receives currently 85% of their net income and not 100%. So in effect, the worker is punished for their work injury with a loss of 15% of their earnings. Another important point is that the employer reports gross earnings and the WSIB calculates your net earnings. This is very important for workers to understand. I know it gets very confusing, but it's where the board, the WSIB, tends to cheat injured workers out of tens of thousands of dollars every year. Because what they do is they'll claim a worker, say a mother or father that has a spouse that stays home and then 4 or 5 kids. I know that sounds a lot, but their tax rate is much lower than that of a single person, meaning their net income is really high. In those cases, the WSIB will say they're single, so that way they don't have to pay them as much. This cheats them out of, as I said, tens of thousands of dollars each year. It's something workers, representatives, and unions, everyone need to be wise of, is when you first hear a worker's injured, is to zero in on that employer's report and see what the employer is saying. Employers will automatically default and say they're single. Oftentimes workers will declare they're single throughout the year, and then at the end of the year claim married with kids, so they get a nice little money. It's sort of like a savings thing. My mom used to do it all the time. The other is a major concern with the current workers' compensation system is that in Ontario, the WSIB has moved to a US-style insurance system of managed healthcare. This is where the WSIB and not the worker or their doctor decides the healthcare for the worker and what they receive. Additionally, and often the WSIB forces the worker to attend a WSIB treatments facility. This is where the healthcare providers are very pro-WSIB, where they have been known to repeatedly force the worker back to work before they are ready or capable. This is simply a violation of one's right of autonomy. That is a right to control your body under Section 7 of the Charter of Rights and Freedoms, Security of Person, and has been long accepted as that by the Supreme Court of Canada. Sadly, the WSIB doesn't know about human or charter rights. Another example, a con, is extremely biased decision makers. Over the past few years, independent legal scholars have noted, and for example, one most common is the authors of Butterworth, which is a legal reference text for representatives representing injured workers at the WSIB appeals and the WSIAT appeals. They've known increasingly that the decision makers have ignored law and common law practice in favor of reducing or eliminating benefits of an individual's claim. Oftentimes, these decision makers will ignore medical evidence in favor of their own hatred to people with disabilities. A good example of this was the Divisional Court of Ontario's decision against the WSIAT, where the panel members ignored all medical evidence in favor of their own opinion, citing that they thought the worker was faking. This, as the court said, was something where the panel members acted outside their jurisdictional authority because they're not doctors. This gets back to my point about nurses being decision makers at the WSIB. Even though a medical person makes that decision in place of a case manager, they too, in theory, are acting outside their jurisdiction, I argue, because they're not acting as a doctor when they're making decisions. They're not examining you. They're not following medical procedures or ethics. Another concerning problem with the current system is forced return to work. This is becoming very disturbing. Currently, Ontario's WSIB has implemented a covert policy that all workers are to be forced back to work. This was noted in Butterworth since 2010 when David Marshall became president of the WSIB and made this policy not because he thought workers could work. He did it solely for the purpose of saving money for the WSIB. That's all it was. In my view, it was criminal fraud. When you use deceit to cheat somebody out of money, this is criminal fraud. It was revealed in a Freedom of Information request that since 2018, less than 5 workers have been found unemployable, which means they can no longer work from that date till the age of 65. This is very disturbing. Many have been forced to appeal to the tribunal, and I've noticed lately in some WSIAT decisions, the tribunal, they've also have been forcing workers to say, or declaring them and saying, well, we think you can be a greeter at Walmart. Ironically, Walmart doesn't have greeters anymore. Or they'll say you can be a parking attendant. They make up these positions. That violates the policy because when they say, can you do this job, they need to look at 2 criteria. Your functional abilities, any disabilities you have. So in other words, what you can do, meaning what you say you can do, with your physical disabilities, the work injury capabilities and stuff, everything, compared to a documented work job, meaning the tasks of the job. They can't just make stuff up. This is becoming very common, and this is one major problem with the current system. Another con or problem identified in the current system is that with the return to work, if you are injured today and you're able to go back to work tomorrow, you receive no workers' compensation benefits. You receive nothing for your lack of functional ability and the significant pain you endure. If you're not able to cut your grass or shovel your driveway or service your spouse, it doesn't matter to the board. The only thing they care about is you getting back to work. They don't care about that right of redress, that compensation for the injury. You get nothing. The only exception is when you've been declared permanently injured. And this takes, ironically, the board has gone from the standard of 3 or 4 or 5 months for injuries to years, 2, 3, I've even seen 5 years. They're doing this in a fraudulent way because they just don't want to pay the money out. It is no other reason. There is, in looking at the documents in many decisions, they don't say, oh, well, you know, he was improving. In the medical, the evidence shows that the worker's recovery was flatlined. There was no improvement for 3 or 4 years, and the board's still saying, no, they can improve. That to me is blatant fraud. The most, probably one of the most troubling con of the current system is a possibility of conviction. Since 1998, the law in Ontario allows the WSIB to be empowered to prosecute injured workers who, in the opinion of the WSIB, were found to be faking. Some have received fines, and some have even received jail sentences. A few have received up to 300 days in jail. What's also disturbing is these individual injured workers receive no representation from the Office of the Worker Advisor. The OWA's opinion is it's not injured worker related or whatever. This is in addition to complete suspension of benefits and the WSIB attempting to recover the benefit payments. So if you were paid benefits for a year, the WSIB suspends future benefits, they demand the payment of benefits for that year, and they throw you in jail. What is disturbing about this is that in many cases, the WSIB has prosecuted and convicted several injured workers without any medical evidence that these individuals are faking. Moreover, some individuals receive jail sentences. Additionally, there is the constant fear of an individual looking over their shoulder for fear they are unjustly being surveilled by the WSIB or their employer. In fact, many law firms and paralegal firms actually are hired by employers or make this their business to get injured workers off WSIB. We're not talking about legitimate concerns. We're talking about even if you are legitimately entitled to workers' comp, they will find a way to get you off. That is very disturbing, and again goes to that point about criminal fraud. In one example, an internal WSIB documents revealed a WSIB investigator in investigating one injured worker was standing by the individual's apartment door listening to see if they were faking while they were inside their home. This is beyond disturbing and violates huge privacy rights. But again, I argue that the WSIB cares not about your privacy or human rights or charter rights. They only care about money. In another case, an individual had a neighbor taking pictures of them while they were on their property and including when they were in their home. In both cases, the WSIB used the unlawful evidence obtained to prosecute the individuals. In the second case, it took the Court of Appeal for Ontario to overturn the decisions, begrudgingly, I add. What is most disturbing is that the law allows the WSIB to suspend benefits and even prosecute any individual with a claim, regardless of how old the claim is. This is an interesting concern because, for example, I was injured in 1997, and the WSIB or the legislature can apply a law retroactively to me. To my understanding, I didn't think this was allowed. So if you were injured 20, 30 years ago, they can change the law for everything. This proves a point, a most disturbing point, and you will hear this phrase a lot from the tribunal, especially the WSIAD, when you ask for reconsiderations. That conversely, compared to when you're doing an appeal, that the board or tribunal can look at your case at any time, regardless of time. So in other words, from their perspective, there is no finality to this disconcerting conduct on the part of the WSIB or the WSIAD. But for us, they have very strict time limits, 30 days, 6 months, and that's it. You're done. You get nothing. This compared to suing an employer, where once the case, if a worker was allowed to sue their employer, once the case is heard and all appeals, rights to appeals have been exhausted, the individual has finality, as there can no longer be harassed by the employer, WSIB, or anyone else in the matter. So with that, those are the pros and cons of the current workers' compensation system as I have raised. I let you decide for yourself as an individual which system is better or worse. I would also like to add that in a court of law, both sides, the employer and in this case would be the injured worker, would bring their own doctors and a judge who's been independently appointed by the government till the age of 75 and cannot be terminated or fired for any reason unless it was legitimate by an act of parliament. Case managers and tribunal and panel members can be easily fired for any reason if they don't tote the status quo, for example. These are very troubling conduct in the way of looking at the system of the current appeal system within Ontario's workers' compensation system compared to the court system. Now, the court system isn't perfect by any stretch of the imagination. There are many examples of judges being disciplined and being forced to, as they say, resign. They've never reached the point of a judge being removed from the bench, because in the higher court, for that to happen, Canada's parliament would have to enact a law to remove that judge from the bench. This has never happened. But there have been many cases where judges have resigned, as we'd say. In the case of the board or tribunal, their staff, they're never held accountable for these intentional wrongs. The one that really concerned me, several, was the one where in Fiera v. WSIAD, the panel members thought he was faking, so they ignored all the medical evidence. Now the court said, well, under judicial review, we reversed the decision. But my opinion, do you think in this current system of the appeals and the compensation system, that was fair for that individual? They lost benefits, they were ridiculed, attacked, accused, they were defamed. This is another big issue. When an individual is accused of faking, it's fraud. Like you're accusing them of a crime, but yet they have no legal recourse when they're, so to speak, vindicated. The board staff, the tribunal staff are never held accountable. They reverse the decision, go, well, here's your benefits now, and here's some interest. To me, that's not justice. So you think about it and you decide. Thank you.